Thank you, guys. Thank you all for coming out tonight, and thank you for everyone who is tuning in online. This can be a hard topic for folks, and it can also be a topic that people are surprised about. And so we're going to take some time tonight to dive into this growing area that Texas Right to Life is involved in, which is patient advocacy, protecting human life through the continuum, and making sure that our pro-life principles that we hold at the beginning of life are consistent throughout those that are most vulnerable and most in need of our protection. So tonight's topic is hospital ethics committees and Texas's 10-day rule. So we will get started here. In Texas, there are two ways in which, if you were currently receiving life-sustaining treatment, there's two ways in which life-sustaining treatment can be removed against your advanced directives, against the decision of your medical power of attorney or your surrogate decision maker. There's two ways. One is when there's a brain death diagnosis on the patient, and the second is under the 10-day rule. I make this distinction because I want us to recognize tonight our conversation will center on the 10-day rule in Texas. That is distinctly different from brain death diagnosis, and that brain death is a topic in and of itself worthy of discussion. But just to know, these are two different situations, and these are the issues that take up the bulk of Texas Right to Life's patient advocacy work. And how that works, our patient advocacy, when families are facing either of these situations, they call Texas Right to Life for help, and we'll get into that a little bit later. But we have a patient portal where on our online on our website that families can enter in their information. It sends the patient portal, alerts our patient advocacy team, and one of our staff members begins to counsel, calls the family and does intake and begins to counsel the family on what is going on, what are their legal rights, what to watch out for, how to advocate with them, for them in a hospital setting, and to secure legal counsel if needed. When we get started, I want to define terms here. Life-sustaining treatment means treatment without which a person, an individual, could not continue living. So that what we see most often, mechanical ventilation support, what normally you would call a ventilator, dialysis, and blood pressure medicine. Those are the three, blood pressure is usually through an IV. Those are the three main forms of life-sustaining treatment that we see that are disputed in these conflicts between the healthcare providers and the family. Defining patients' wishes. The law that we're going to talk about tonight allows for the removal of life-sustaining treatment against a patient's treatment decision, and that treatment decision can be manifested in several different ways. The patient's wishes, that maybe the patient is cognizant, okay, and can make those wishes known at that time, which we'll see an example of in a minute. So it doesn't matter, patient's wishes, if that is the individual who can speak for herself, or maybe the patient's decision is a surrogate decision maker. I have told Sarah, Sarah is my next in line to make decisions for me, and so her judgment it's substituted judgment for mine. So if her decision, that's what we talk about and mean by patient's wishes, or your agent subject to a medical power of attorney, or maybe you wrote it down. Maybe you have a will to live, or what other people call a living will sometimes. Maybe you wrote those wishes down. Every time when we talk about patients' wishes, we mean all of the above that I've described. And we already talked about brain death determination as not being the subject of what. If you're in a 10-day rule, then more likely than not, you have not, there has been no allegation that you have suffered, that the patient suffered brain death. There's several high-profile cases in Texas. Now, I want to put this into perspective. I mean, Texas Right to Life in 2020 alone fielded about 63 calls for families whom we counseled for patient advocacy. In 2021 so far, I think we're probably up to close to 20, maybe close, 15 to 20. We are 2 a week, 3 a week, active cases going on right now. And so when we talk about high profile cases, these are the ones that made the news. And there's a small sliver of the population of the population whom we help that make the news. But there's something going on in their case that makes being able to put some pressure on a hospital facility to respect the decision of a surrogate or of a patient that requires this last ditch effort to stir up some media. So this is Miss Carolyn Jones, and she was a wonderful lady back in 2019, and we were called to help by her husband and her daughter, and she was out of Beaumont, and she was here in a hospital in Houston. And one of the factors in her case that I'd like to bring your attention to, the treatment that was disputed and that the physician sought to withdraw over the wishes of her husband, were ventilator and dialysis. Okay, so Miss Carolyn had been receiving dialysis on an outpatient basis for many years. Okay, she did not when she went into the hospital, she already required dialysis. Okay, that wasn't a reason why she was in the hospital. But under the statute, life-sustaining treatment includes dialysis. And so the family went through the 10-day situation, went through the 10-day rule invoked on Carolyn, and the day came. She was supposed to be removed from life support at 2 p.m. on a Monday. Our friend, our media and communications director, Kim, was asked by the family to go and be in the hospital room with them. And the family was all around begging the hospital staff not to remove life support. I was in my office at our old office that day, and about 4 o'clock, I get a text from Kim. She says, Carolyn's still breathing. Okay. A few more hours went by. She was still breathing. So they had removed the ventilator, but she was breathing on her own. A couple days passed, and Carolyn's days for dialysis were Saturdays and Tuesdays were the days that she normally received dialysis. So she made it through the night, breathing on her own. So the next day, bright and early, we get to the hospital to be with the family because now it seems like maybe her conditions changed. Right, maybe it's not as dire as the physicians who invoked the 10-day rule thought, because she was looking at you when you walked in the room, moving her head, and she was still breathing. Well, I had been concerned about the dialysis aspect because I was not allowed, even though I was the family's attorney, I was not allowed to be in the room when they had these meetings, a couple meetings with the family. And I had reiterated to hospital counsel that my client's wishes her daughter's wishes were that her mom not die of kidney failure, because she used to be worked in hospice care, and she saw that. That's not how she wanted her mom to die. And I'd reiterated that to hospital counsel. And when the family got out of this meeting, a different meeting that I wasn't allowed to be in, the daughter said, I got it. They told us dialysis wouldn't be an issue. Well, I was a little skeptical because we didn't have it in writing. Okay. Well, Tuesday came, and they're not providing dialysis to her. They would not do dialysis. So Tuesday night rolls around, still no dialysis. We get to Wednesday morning, the facility will not do dialysis. Finally, the risk manager comes out and just essentially yells at the family, we're not doing dialysis. That's under the 10-day rule. Stop asking. Finally, here this woman, she was looking at you, okay? And by gosh, if they didn't kill her by removing her ventilator, they were going to kill her by not providing dialysis to her. I had asked the hospital attorney, I said, how much for one dialysis treatment so that we could try to get her somewhere else but stabilize her at the point. I said, Texas Right to Life will pay for a dialysis treatment. How much? Tell me how much it is. And nothing. And so we ended up Wednesday night at about 9 p.m., 10 p.m. We hired a private ambulance service through our patient advocacy fund to pick her up, discharged her against medical advice, and took her around the corner to to an emergency room to where they had to stabilize her, which just in her case meant a dialysis treatment. At that point, because we had made there was such a ruckus in the media about her case, the hospital that we ended up going to, they pretty much rolled out the red carpet. Okay, they're like, we're going to take care of her. Don't you worry. I'm like, okay, I think that's a good idea. And they worked with her payor source. There were just wrinkles that had to be worked out in order to get her to an appropriate care facility with a lower level of care that she needed, where she continued to live until she passed away naturally without being euthanized. Oh, forgot this. This is another case back in 2015 that made the news. This is Chris Dunn. He was about 46 years old here in Houston. And you can see, we'll start this video.
Look at me. Chris, look at me. Is it okay if I hired some lawyers to help us? Is that okay? Huh? Was that a yes?
Very good. Chris, my name is Joe Nixon, and this is Trey Trainer, and we're the lawyers. And you want us helping you?
Yes.
Good, good. Chris, we're trying to make sure the hospital continues giving you good care. Do you want to stay alive? You pray?
Yes, he's praying.
Praying, okay. Good. We're gonna pray for you too.
Impacts. It is those who support the 10-day law in Texas, the medical lobby, the hospital lobby, other groups that identify themselves as pro-life want you to believe that that patients are not cognizant. Putting all these other factors into someone's life without recognizing that we value human life just for the mere fact that it's human life. And so these are the real people and situations, people who can make their own decisions, people who understand what is going on, yet they are subject to the 10-day rule. This is baby Tinsley Lewis. This case started in, well, I guess the fall of 2019. She's 2 now. Yes, she just turned 2. Actually, so this is a very old picture. But baby Tinsley Lewis, she is the subject of Cook Children's Hospital up in Fort Worth, trying to remove her life-sustaining treatment against her mother's will. This case is ongoing. We have lots of information regarding it on our website, but her mom says no, and we've had to file a constitutional lawsuit in order to protect both her mom Trinity's rights as her surrogate decision maker and to save Tinsley's life. This was a recent case in April of 2020, right when COVID hit. Her name is Lucy Wynn. She was a 72-year-old woman at a hospital in Dallas, admitted after cardiac arrest. The hospital had said there was no hope for Lucy and that they believed her quality of life was too low with no hope for getting better. And that due to her condition, they said they could not find a transfer to another facility. The family called Texas Right to Life before the ethics committee meeting, and 2 of our patient advocates attended the meeting and helped the family present their side. So Lucy was Catholic, and that was something that her family really leaned on in trying to represent what Lucy would have wanted in this situation had she been able to speak for herself. They said that Lucy believed strongly in waiting for God's timing, and her daughter fought extremely hard for her. After our patient advocates went to the meeting, the ethics committee miraculously decided not to start the 10 days, and Lucy was transferred within a week to a nursing home in DFW, and where she lived over 10 months before passing away naturally this past February. And that's what happens sometimes. It's sad, but it's really sad when to think of all of the cases that just because they had an advocate in the room, the hospital finally decided to do a little extra legwork to move, instead of ending, when someone's ending someone's life isn't on the table anymore, it mobilizes the facilities to actually figure out what's wrong with the payor source, or okay, maybe call one more admissions person to ask. And so those are, we received, when Lucy passed away last month, we received a beautiful note from her daughter who just expressed how much at peace and thankful she was that her mother that her mother was allowed to pass away naturally without death being imposed on her, and that she felt that was allowed the family to have a lot of peace as well, in knowing that they fought for their mother and that they protected her mother just like she had always protected them. And her case is a great example of what incentivizes hospitals to work with families to find transfer solutions when the 10-day countdown is no longer an option. So I told you I want to put the faces to the statute as we walk through how this process plays out, what it is, and so that you can visualize real people, real families walking through the process. So the 10-day rule, it's a statutory scheme at the very end of the Texas Advanced Directives Act. The Texas Advanced Directives Act, very ironically, lays out how do you go about letting people know what your wishes are. But then at the very end, very last part, it says, unless we disagree with you, then we get to win. This chapter, the law is saying, here's all the info you need to make a decision to refuse care for yourself. But if you want care to be provided, that's only if we think it's okay to do that as well. We get the final word. The 10-day rule was a progressive model that was signed into law in Texas in 1999. And what was going on nationally at that time was there was a very in concert movement to try to inch towards physician-assisted suicide under state laws across the nation. And this 1999 law was actually started in 1997, but it was their foot in the door, okay? And Texas was the first state doing this, and it was supposed to Texas was supposed to look towards this as a model for all the other states to follow in this sort of encroaching towards making physician-assisted suicide and euthanasia normal. What happened, though, was the Terry Schiavo case out in Florida in the early 2000s. Terry, we're coming around a generation now who actually do not know the Terry Schiavo case. I remember growing up. I remember watching it, but was really young. But I do remember that the Terry Schiavo case on headlines in the news. And so for any of our younger viewers out there, make sure you Google and read up on the Terry Schiavo case. But basically, Terry Schiavo was a young woman and who, through a lot of court battles between her husband at the time and her parents, her feeding tube was removed and she was allowed to starve to death. And it took acts of Congress tried to intervene, the courts in Florida and the United States Supreme Court, but it dominated the headlines right after this, and it kind of took the wind out of the sails for the rest of the country on pushing the brakes of this different, we're going to sanction killing of sick individuals. That's how we're going to approach it. So it took the wind out of those sails, but unfortunately here in Texas, we were still stuck with the statute. The process. when it is invoked, when the 10-day rule is invoked, what can you expect? The situation that would be occurring is that the patient or family wants life-sustaining treatment continued. This is treatment every time that is already being provided to the patient. So the family is not asking for a chemo treatment for a broken foot. Okay, it is treatment that is currently being provided, and it's working. That's important to understand. It's working for its intended benefit because the patient is still continuing to live. The treatment is doing its job, what it's supposed to do. But somebody disagrees. An unattending physician disagrees and wants to remove life-sustaining care. So Dr. Cook comes to the family of Miranda and says, I want to remove life-sustaining treatment. And Miranda's family says, nope, no way. And if the physician wants to press the issue, this statute is available for him to do that in order to override the wishes of Miranda's family. So the attending physician wants to withdraw life-sustaining treatment, and then they will ask for an ethics consult. Well, what treatment is it? We went through these. Yes, examples were life-sustaining treatment, dialysis, blood pressure medicine, discussion of medically inappropriate. We might get there in a minute. Okay, we're moving on. So physician wants to remove the treatment. They request an ethics consult. Then the hospital ethics committee, empowered under the statute, convenes to hear the physician's case. In this process, what are the patient's or the family's rights? There are not many at all. You are entitled to 48 hours notice that this ethics committee meeting is going to happen. That notice can be either verbal or written notice, depending on the hospital and how sophisticated they are. Usually the more major hospitals will send a letter. Smaller rural hospitals that just kind of sloppily doing the statute, they may not do that. So 48 hours notice of verbal or written notice, unless that time frame is waived. One of the first things that we do, because you need all the time you can get. So if a family calls us and they're hearing terms like, well, the doctor's saying that the treatment is futile, or the doctor's saying she's been here a really long time, or we hear a caseworker say the money's ran out, Medicare's not paying, she's almost out of Medicare days. They kind of sense that something is brewing. We tell them, do not, if anyone ever comes to you and says, hey, can you meet with the ethics committee meeting tomorrow? You never say yes. Never, never, never. Because you've just waived by agreement this 48 hours notice, which isn't enough time anyways. So that's for one of the first things we counsel patients. And then, and this is so nice, the statute says that you may be given a description of the process. Not shall, but you may be given a description of the process that's about to determine whether your loved one lives or dies. And any policies or procedures that the hospital has put together for this, they can decide that you get to know that information if they feel like it on that particular day. The family is entitled to a written printout of the statute. Basically, it's a written printout of the statute. So, in your grieving, you get to read a law, which you may or may not understand. That's okay. And this is about the only thing that is helpful, marginally, a registry list of helpful allies. This is where some of Texas Right to Life and friends receive calls sometimes from the registry list. So if you look on this list, it's maintained by the Department of State Health Services, and it will say, here are some people who may be able to help you and what they can help you with. Texas Right to Life is on there, and our description says something, helping to navigate treatment I've forgotten the word, disagreements with the facility, help arrange a transfer and secure legal counsel if necessary. There are a few attorneys on the list with whom we regularly work. And other organizations like HALO and the Healthcare Alliance, yes, HALO, and Terry Schiavo's brother, the Terry Schiavo Foundation. I'm just tripping all over my words here. I should not start naming names, but the Terry Schiavo Life Foundation, I think is what it's called, that you can call and to try to help. And we all talk to each other and try to help each other out. That's about the only helpful thing. You are also now recently required to be given a copy of your medical records. We were finding in our advocacy, in our advocacy efforts that families were not being given access to medical records, but yet they were expected to try to arrange a transfer for this patient in ICU to another facility without medical records. I mean, so that's an empty promise. How on earth could you even begin to do that? So we had to proactively place it in the law that you are entitled to your medical records during this time frame, so that your family might have some help, some chance at trying to advocate on your behalf. So what happens once you're inside the room and inside the committee, okay, and the committee meeting's about to start? The number and identity of who is on the committee fluctuates. Some hospitals can have 7 members. Some hospitals can have 16. My very first ethics committee meeting I walked into, and that's about what I counted. It was 16 people around the table here to to tell a mom and stepdad that they were going to remove the ventilator from their 21-year-old daughter. About the number and identity. Everyone in this committee, some of the hospitals like to call it, say that there's an independent ethics committee meeting, but every member of that committee is always affiliated with the hospital. Now, there may be 2 or 3 members of the committee who are former patients or at a children's hospital, maybe parents of former patients, but they all have, absolutely the majority of them are employed by the hospital, right? They are financially tied to the hospital, working side by side with the physician who has called for this ethics consult, which is a misleading term anyways, because it's a decision is made. It is not just a recommendation. So then the physician presents his side. So the doctor will sometimes the family is not allowed into the hospital into the room during the time that the physician is presenting his side of the story about why he thinks that this patient should be removed from life support. And that poses a couple problems, because how you're not able to converse with the physician and poke any holes into or offer any contravening quote unquote evidence in a situation like that, but the physician is allowed to stay in there while you give your talk about your loved one. And some of the hospitals, this used to happen where the family was excluded from the time when the physician when the physician was giving their report to the ethics committee. That has tempered in the last several years. The more we've hollered about it, the hospitals are kind of, letting families go in, but it used to be a real problem. The family member presents their side to allow to talk. Sometimes some hospital systems will allow the attorneys to talk. Sometimes they won't. The family and physician then are dismissed for the committee to deliberate and make a decision. Okay, that's how it's supposed to work under the statute, that you hear both sides and then the committee talks amongst themselves. But a lot of times you can tell there's been a pre-meeting, okay? And that decision has been reached. The very first ethics committee meeting I attended on behalf of a client that I was talking about a minute ago, when we walked into the room and started to sit down, the social worker started handing out this piece of paper to everybody. So I look, to everyone affiliated with the hospital, of course. So I'm like looking. The hospital attorney was sitting next to me, and I said, "What is this?" I looked at the hospital attorney. I said, "This can't be the decision because we haven't had a meeting yet, and that's not how the statute works." And the hospital attorney, she got visibly nervous. She looked at the social worker. "No, we haven't made a decision yet." And the social worker just kind of nervously takes all the papers back. But if that family hadn't had an attorney sitting there, even an attorney fresh out of law school, to notice that, but how many more times has this happened to families who have absolutely no advocates? Here we go. I get a little worked up, so excuse me. The decision of the committee. So when the committee decides to who wins, does the family win, does the patient win, or does the physician win? The written decision is then given to the family. So you get notice, you get something written that says we're going to unplug your wife in 10 days on the tail end, but you don't get that written explanation at the beginning of the process. But if the committee grants the physician's request, that decision is binding, okay? Hospitals like to hem and haw around this and say, well, it's the recommendation of the hospital, of the ethics committee, that life-sustaining treatment be withdrawn. I mean, that's just basically trying to put lipstick on a pig, okay? It doesn't change you can call it whatever you want, but at the end of the day, that is a decision, and after 10 days has passed, that facility, that physician can remove life support from a patient and not be subject to any administrative liability, zero criminal liability, and zero civil liability. At the time of, this is the part of the process where if they start the 10 days, you've got to be given the medical records. The facility only must provide care for the next 10 days from when the family receives both the decision and the medical records. Sometimes we're able to get the 10 days stopped because they forget to do both of those. Okay, and anytime that the statute is not followed, then they will lose that liability immunity. And then the statute says that the physician must make a reasonable effort to transfer. We are constantly arguing about what is a reasonable effort, and you really have to be on that. When the 10 days expire, the facility can remove the life-sustaining treatment, and like I said, they are provided complete liability for that decision, for that action. Whereas any absent working in this within this scheme, there would be some serious liability repercussions in all three of those areas. What about a transfer? Physicians, like I said, must make a reasonable effort to transfer, but there is a provision that also that says if a decision to remove is done under the 10-day rule and you do get transferred somewhere else, if you are readmitted back into that same facility within 6 months, they don't have to go through the ethics committee process again. All they need to do is the patient's attending physician and a consulting physician who is a member of the ethics or medical committee of the facility document on the patient's readmission that the patient's condition either has not improved or has deteriorated since the review process was conducted. So it's like, oh, well, we didn't get to kill you the first time. Now you're back. We're going to try it again. Who does the 10-day rule affect? Well, the short answer is we don't know. There is no mandated reporting in the state of Texas, despite the legislative efforts of Texas Rights Life, the medical lobby, and even some of your faith-based organizations and other pro-life organizations. They just simply don't want to know that how many times a facility in Texas operates. So Texas Rights Life, we keep our own stats. We keep our own demographic stats, payor source, income levels and ages. We keep those so that we have an idea, and whether what comes through Texas Right to Life doors is the totality of what's happening in Texas or just a sliver. We don't know the answer to that. Texas Right to Life advocacy. I've told some more stories, but I will go back to the very first. I just cannot imagine. I'll go back to again, that was just such a horrible ethics committee meeting. The 21-year-old, my first ethics committee meeting. When I questioned the doctor, it was revealed that he'd been on vacation for well, first of all, the meeting had gotten moved because he was on vacation. And so I started to put the pieces together, and I realized that he hadn't treated Brianna, that was her name, in several weeks. Okay. Here you are advocating to remove life support. Okay. So I noted that he hadn't seen her treated her in a couple weeks, and I asked what her ventilator settings were. And I remember they were whatever he said, it was a very low amount, which triggered in my mind that was within the weaning stage. So I asked the question, why haven't we tried, could she be weaned? Could she be weaned? And he said, yes. And I said, then why are we sitting here just having a meeting about whether to remove her ventilator prematurely? Why don't we just try to wean her? And his answer was, well, who would want to live with MS? I kind of, okay. I said, well, actually, that's a decision for her mother to make, not for you to make. And it made the room a little uncomfortable. And I was really glad that we had elicited that reason, that quality of life judgment. Because look, everyone, I'm not saying that every single person sitting around an ethics committee room has nefarious intent, okay? But if you don't ask the right questions, you don't see the actual reason behind wanting to remove life support. And when you do, the statute, many people mistakenly think it's because the treatment's not working. No, this statute covers up quality of life judgments that should not be made in a committee room with people who have never met a person. Those are decisions that belong to families, to spouses, to best friends, people who know what these patients would have wanted to do, not some 16-member committee. So in Brianna's case, the committee decided not to remove life support. She was weaned within 3 days, or I don't know, it was a very short amount of time. By 2 weeks later, she was out of that hospital, and she is alive today. She's alive. I mean, she's had health problems, yes, because she has an illness, right? But 5 years later, she's with her mother. Others. Oh, goodness. I think I had any others. Oh, yes. Maybe this was Thanksgiving of 2019 or 2020. I can't remember. But it was the week of Thanksgiving. We get a call from East Texas, a family in East Texas. And this facility had started the 10 days on this elderly woman. I mean, this woman was 99 years old, okay? 99. Hospital just thought she was too old. And that's what they told the family. Just too old. Well, there was the family's like, well, yeah, she's old, but that doesn't mean we need to kill her. So this is someone's grandma. My grandma is 90, okay? The issue, after our patient advocacy team got involved, you know what the issue was? Her insurance coverage would not cover the actual physical transport from the hospital to a nursing home. It was about $1,200. Okay. That was what the holdup was. And so instead of trying to figure a workaround about that, the hospital's answer was, well, we have this law here that allows us to just pull the plug. We're just going to be done with it. Okay. Instead of putting a little extra work into protecting this woman's life. because she is human. And so that's where our patient advocacy fund stepped in that instance. And I mean, the family, they had 3 days. And this family was just desperate. We can't get $1,200 together in 3 days. Okay. And so that was what something that our patient advocacy fund was able to provide ambulance transfer that she needed to her to a nursing home. And the family did not have to deal with her passing away from forced euthanasia over Thanksgiving holidays. The problems with TADA, they're really great. They are huge. I want to circle on no criteria for doctor's refusal. Okay, no definition of inappropriate. The only standard in the statute is that treatment that a physician has determined to be medically inappropriate. Okay, medically inappropriate is not defined anywhere else in the law, in that chapter. And like I said, it's just a euphemism for quality of life judgment, because by actual definition, the treatment that's being provided is helping to sustain the life of the patient. We were, Greg, sitting right here in front of us. This past week, we were in an ethics committee meeting via Zoom over with a case up in, had too many, I can't remember off the top of my head. Oh, yes. So but I asked the physician who had called, does this patient need dialysis? Yes. Okay. Do her kidneys need dialysis? Yes. Is the dialysis treatments working? Yes. So the dialysis treatments are helping to, helping Mrs. M's kidneys work. Yes. Okay. So the problem was not that the treatment was not working, it was that it was working. And that's something that I just always reiterate to folks, because the breadth of what the statute deals with is pretty large. Okay, we've been through that. We've been through a little bit. No enforcement of facilities transfer. That's incredibly true. Often our team will follow back up with other facilities to find out what was the question. Often we have to send in questions to the hospital caseworkers to say, okay, we see that this hospital A said X. Okay, we'll ask them about Y and Z. It's like, come on, let's go. Let's do our whole due diligence here. Abrogation of constitutional power. And this is the subject of a constitutional challenge going on right now in the Baby Tinsley Lewis case up in Fort Worth. Who gets to decide? The government is the one who decides what is the lawful means of dying, when it's against the law to kill someone and when it's not against the law to kill someone. And what this statute has done, the legislature has said, okay, we're going to invest this decision. We're gonna abrogate this power to determine the lawful means of dying to all these hospitals, these hospital ethics committees. And that's one of the arguments that is being successfully made in the Second Court of Appeals Tinsley Lewis case. We're going to see. We're just going to go. Sarah told me we were about to run out of time. Let's talk about, ignore this. Let's talk about due process rights. This statute, you don't have the ability to be heard by a neutral arbiter because, like I said, everyone is affiliated with the hospital. You don't have sufficient notice. Okay, you don't 48 hours notice. Absolutely not. To understand the magnitude of what is going on and to seek counsel or to find someone to help you. I mean, that just doesn't. 48 hours is just definitely not sufficient. And so this is this 046 procedure provides fewer protections to a person facing removal of life-sustaining treatment than Texas provides to tenants facing eviction from a rental property, to workers before their wages may be garnished, or to owners of automobiles threatened with repossession of their car. So true. I think this was taken from the Chris Dunn lawsuit. I think. So what were some of the recent statutory changes? Up until 2015, this definition of life-sustaining treatment included food and water. Okay, so if you were receiving nutrition intravenously or through a PEG tube inserted in your stomach, then that was subject to the 10-day law. We could just stop feeding and hydrating patients. You know, they could just starve and dehydrate to death, and we thought that was probably not okay. So this bill changed to exempt. Now there are, in the legislative session, there's just always a negotiating table somewhere. But the artificial nutrition and hydration has 4 exceptions. If the ANH would hasten the patient's death, then it can be the subject of an 046. If it was medically contraindicated, so that means medically contraindicated means that the treatment isn't actually doing what it's supposed to be doing. Medically contraindicated such that the provision of the treatment seriously exacerbates life-threatening medical problems, not outweighed by the benefit of the provision of the treatment, result in substantial irremediable physical pain, not outweighed by the benefit of the provision of the treatment, be medically ineffective in prolonging life, or be contrary to the patient's or surrogate's clearly documented desire not to receive artificially administered nutrition and hydration. The first 4 first 4 exceptions deal with when ANH isn't feeding and hydrating the body like it's supposed to be, when it's not working. And then the 5th is respecting the wishes of people who have said what they do and do not want. Senate Bill 11 back in 2017. During these cases, we we're discovering that there were do not resuscitate orders. There were do not resuscitate orders placed in patients' files who were the subject of 046 hearings that family never consented to. And so we had to change that legislatively to require consent, because in the absence of explicit consent, it was treated as medical orders, and it would just vary from hospital to hospital. Some hospitals would say, I would never put DNRs on a patient without their consent, but it still was happening. And so we encounter this in this entire scheme in advocating for patients. We encounter medical professionals who just can't believe that this occurs, right? Because it's so against their conscience. That's not how they were trained. They don't work with people like that. And so it's hard to imagine that this is a problem in real life and not just on paper. And that's why we try to share stories when it helps and not harms the patient, to show what it is that we see. My brother-in-law about a month ago has suffered a very traumatic brain injury, and so we're working to advocate for him. And my sister's best friend is a doctor, and so is 2 of her best friends are doctors, and we were outside, and they were about to have a meeting with the hospital, with some of the hospital personnel, and she just looked at me. My sister's best friend was going with her, and she's like, I was telling her, look for these buzzwords, ask these sorts of questions, and she just said, Emily, people just don't do that. And I said, she said, I know you see the worst. I said, I know, I do see the worst of what goes on. And so, yes, I am jaded. But if you don't, I've seen too often what happens if you don't have a good care team that believes that. I've just seen so much difference in the care team that my brother-in-law has been lucky to have, because they believed in him and that his life was valuable and that he deserved a chance. And it breaks my heart to see when other families do not have those individuals around them. And so that's what our patient advocacy team does, is to come in and tell them what happened to them. Sorry. We're going to. Okay, we've got a couple legal challenges going on that Texas Right to Life has funded. In 2015, the Chris Dunn, he was the gentleman you saw who was praying to stay alive. We did an agreed temporary restraining order with the hospital in this situation. And so actually this case was eventually he died. He passed away naturally about a month later around Christmas, which is, peaceful for families to know that their loved one passed away naturally, that they fought, they did everything. And that itself is valuable, okay? That leaving your loved ones with a peace of mind like that, that itself is valuable and is one of our aims. We know that every patient that we counsel is not going to have a miraculous recovery and get up and walk out. We know realistically, but it is about respecting that person to their natural end, as a Christian organization, to when God calls them home, and not speeding, not hastening, not doing something that will that will cause their death. And then I talked a little bit about the Tinsley Lewis case that's going on, right? That's still ongoing at Cook Children's, and she's won. I mean, she's won so far. We're gearing up for trial, and in the near future. But we've been arguing since 2019 about whether Cooks gets to remove her life-sustaining treatment while we litigate. Okay, that's what we called on a temporary injunction, and it was we won a temporary restraining order, and then won on appeal at a temporary injunction hearing, an appeal of a temporary injunction, and that's where we are right now. You can contact us with Texas Right to Life. I don't use Twitter anymore, really, but this is our email address. Like I said, our patient portal on Texas Right to Life has a lot of great information. If you need help, you can always reach out that way. And I don't know if this is allowed in the Academy, but if you would like to contribute to our life-saving efforts here, our Patient Advocacy Fund is a function of our 501c3 that you can find on our website, and that is how we fund litigation. That is how we fund transfers, second opinions that we have brought in for physicians to assess assess patients and help get them the care that they deserve. So that is all.
If you all have any more questions, please remember you can text them to 833-343-0269. So the audience does have some questions for you.
Okay.
Does the law list any medical criteria the hospital committee has to look at when deciding if treatment should be withdrawn?
Absolutely not.
In the current political climate in Texas, is there momentum for cleaning up the flaws in the 10-day rule?
Yes, there's momentum legislatively and judicially.
Has Texas Right to Life noticed if there are certain demographics of people who are more likely to have the 10-day rule invoked on them than other people?
Yes. White people are few far in between. That's just minority demographics, definitely. With COVID, our data, Hispanic individuals are more seriously affected by COVID. Okay, so I think that we saw that in national data, the Hispanic population is having more severe consequences to COVID, and that is borne out on our scale. Okay, a lot of our COVID case, a lot of our life-sustaining removal cases that are COVID related, they're with Hispanic individuals.
And is it ever medically appropriate to remove life-sustaining treatment? And if so, what are some examples?
That is a great question that deals with medical ethics. So medically, you asked medically appropriate?
Yes.
Yes, when the treatment is not achieving its intended benefit. Like the exceptions to providing food and water. If the food and water is actually not nourishing, not hydrating your body, it's doing more harm than what it's supposed to be doing, which is doing your body good. Yes, then that would be an instance where removing that treatment is not. I'm not
like
word vomit over here.
Medically appropriate.
Yes.
Okay, perfect. Thank you.
But for a deeper discussion on medical ethics, tune in, I think it's next week, to John Sego's talk, our legislative director, who is also just knows all. He's doing his PhD in bioethics right now. So you should tune into that.
Yes, definitely tune in. What would you say is the solution to the 10-day rule? Is it simply that we should just give them more time than 10 days?
We do not like a countdown on this at all, because then when you remove the 10 days, when you remove the countdown, then the facility they're more motivated to actually find a solution to this disagreement between the family and the doctor that does not involve killing someone. Okay? When you put that there's an end time where they're going to be relieved of duty, they're going to be relieved of liability and relieved from caring for this patient, all they have to do is find a way to wait that time frame out. And that's much easier to do and detrimental to the patient than doing the work that to transfer the physician, transfer the patient to medically work on an aspect of the patient that would get the patient ready for a lower level of care, an alternative care setting. Oh, I'll tell you, in the Carolyn Jones case, we're sitting in front of, this was like a pre-ethics committee meeting, I guess. I don't remember at what point it was. But the social worker assigned to the case asked the caseworker, okay, well, could she go home? Like what gear would she need? What care would she need in order for her husband to care for her and bring her home? And the social worker's response was, well, that's not the right question. The question is, should she go home? Should she live? Is it worth her to live? Quality of life. Joe Nixon, our other attorney at the time, Joe goes, that's not the question we asked. Can she go medically? Can she go home? And the answer to that was yes. Okay? Not so.
And someone asked, I think this was in regards to the thing you mentioned about Chris Dunn and the patients having less right than, an automobile owner. What does 046 stand for?
Oh, sorry. Yes, 046. That is simply the statute citation. That is simply, you can find the statute. It is chapter 166.046 of the Texas Health and Safety Code. Sorry, I should have defined that at the very beginning. And so for short, we just call them 046 because that is where it's like we all call things 501c3s. Oh, they're a 501c3. Well, that actually means that's the corresponding section of the federal tax code where you find the rules for organizations, and they're codified under 501c3. So it's just a little vernacular lingo to refer to something.
Thank you. And last question, what treatment can be removed under the 10-day rule?
Anything that is life-sustaining treatment. Most often what we see are ventilators, dialysis treatments, and blood pressure medicines that are intravenously given.
Okay, well, that is all. That concludes our Q&A portion of tonight's session. Thank you so much, Emily.